They wrote recommendations to the government. They have put the recommendations online because my time is almost up. It's basically recommending to governments to enact laws, reform laws, have public policies that will empower women, improve laws that improves women's safety, access to childcare and business opportunity, to establish framework to support the effective implementation of laws, and prohibit sexual harassment in workplaces, prohibit sexual harassment in public spaces, in education, online violence against women, financial support to parents, legally binding quotas for women on corporate boards, and quite a lot of recommendation, equal retirement benefits for women and all that. This is the World Bank looking specifically into key areas. But here's what the World Bank report says. That I'll have to read this one out. It says that the gender gap in the workplace is massive. In fact, much wider than previously thought. Although economies have made notable progress over the decades in enacting equal opportunity laws for women, today women enjoy less than 2/3 of the legal rights available to men, not 3/4 as previously estimated. The lower number reflects the major deficiencies revealed once two new key indicators were tracked for the first time this year. And those key indicators was safety and childcare. So, and it says that deficiency in these two areas discourage women from entering the global workforce. When these additional indicators are taken into consideration, no country provides equal opportunity. No country provides equal opportunity for women. Also, most economies also score poorly in laws pertaining to childcare. Women spend on average 2.4 hours a day more on unpaid care work than men, much of it involving children. Expanding access to childcare tends to increase women's participation in the labor force by about 1 percentage point initially, with the effect doubling within 5 years. Only 62 economies, which is fewer than a third, have established quality governing childcare services. As a result, in 128 economies, women may think twice about going to work while they have children in their care. So you now see the underlying reason for this webinar being convened today. Another factor that that report looked at, which was coming later when the presentation on indigenship comes in, is who chooses residence and domicile in a marriage. The World Bank asked that question. And the answer, we all know, you get married and move to wherever your spouse says, not unless it's, the woman is from maybe a part of the world that their passport holds some kind of power. Another question that report asked was, do women get jobs same way as men do? What extra hurdle do you have to jump through if you are a woman, if you are applying for the same job as men? Will you be asked certain questions? Are you married? Do you have little children? Do you plan on having children soon? Because everybody will worry if you are at a particular stage in life to know whether they want to hire you or not. Safety in public spaces like public transportation. How safe is it for you to stay in a workplace till as late as you want to and not have to face danger? Are there any travel restrictions if you are a woman? Do you need to get approval from anybody before you can get a passport, or do you need permission before you can travel, or do you need permission before you can travel with your kids? Things like passing citizenship to children and foreign spouses were some of the questions asked in that report. So at the bottom of the screen, you see it, wbl.worldbank.org is the website where this report is located. So that is all from me. On the screen is the email for the WILIL Nigeria Project. Drop your comments in the chat. chat box, or if it's maybe a longer discussion or need to reach any of the project team or to reach the correspondence desk, it's wililprojectnigeria@gmail.com. So thank you so much for this time given to me. I will be signing off for now, and thank you very much for listening. Thank you.
Well, don't sign off totally, because if we do need to ask if there are questions, Ms. Comfort, please get ready to address and answer them. Thank you so much for that wonderful presentation. That was very, very educative. Thank you. So very quickly, we'll move to the very first session, the plenary session of the day, which is titled Gender, Roles and Concepts. So the session just basically tries to will seek to examine the traditional expectations and caregiving responsibilities, as well as the institutional structure that would support the growth and influence the growth of women in the judiciary. So the session promises to be very interesting. It's a session that will share stories of innovation and courage. And it will also share stories about how women have been able to balance some of their caregiving roles and responsibility with professional distinction, and how leaders have also been able to build workplaces that have that now reflect, fairness and inclusion. We'll hear all of that in this session. Our first speaker is Honorable Justice Adenike Josephine Coker, JP, of the Lagos State High Court Judiciary. She's also currently sitting in Gambia, in the Gambia High Court at the moment, but she's joining us from Gambia, and she would generally just explain the interplay between gender roles and caregiver responsibility, as well as institutional support that has aided, that has empowered women in their journey in the judiciary. She'll also share practical insights of practical examples of how women have been able to navigate this journey and the demands of family, work, life, and service. And so very quickly, the presentation promises to reflect some of her past experiences and how she's been able to, over the years in the judiciary and Lagos State. Justice Coker, the floor is yours. Thank you so much.
Thank you, my Lord, the moderator, Honorable Justice Oshodi. Thank you very much. Good morning to everyone. I believe my Lord Oshodi J has laid down protocol, but it behoves on me to pay my respects, of course, to the Honorable the Chief Justice of Nigeria, who was the past president of NOJIN, and Honorable Justice Kekere Okun, GCON, and also to the president of IAWJ currently, and the past president, Honorable Justice Bintan Yako, who is also my Queen's College old girl. So, I need to acknowledge that. I also pay my respects, of course, to the president of the NOJIN currently, the Honorable Justice Domba Mensen of the Court of Appeal, and revered appellate court justices and chief justices, other justices, and the organizing committee of WILIL, who have brought us here today, magistrates, members of the inner and outer bar, and other stakeholders. And I will rest at this point on established protocols. I bid us a very good morning, and I believe that the previous speakers, both my Lord and Ms. Umaru, have laid out what I would say are the theoretical aspects that have guided both the judiciary and women in general. I especially love the last speaker's pictorial expression of the hurdles that women have to go through. So I thank especially the organizers of WILIL and for this webinar for raising this very, very important topic, which affects the administration of justice, and particularly concerning the welfare of judicial officers, women judicial or female judicial officers, because the numbers are rising. As my Lord Izoba said, they're rising, they're not quite there. It's not, we have not yet achieved the 50-50 across our jurisdiction in Nigeria, but we're on board, and therefore we are impacting justice delivery and equitable access for all litigants and court users. I believe we have a PowerPoint. I don't know if that is going up. But I think the theme, which is going to guide our discussions today, has been well enunciated, and which is to address the challenges that women face, especially in our legal and judicial workspace, in balancing career and family, and this, of course, resonates deeply with me because, and I believe that is why I was asked to speak today, because I was one of those who had a child just before I was appointed. I had my last child in February 2000, just a year before I was appointed as a judge in May 2001. And it was, I would say it was God working at his best time, because I had been shortlisted the previous year, but I didn't know that I was about to be blessed with a child. So in fact, my disappointment was the blessing of my last son. But anyway, so I was sworn in when my son was just a year and a few months, and therefore no longer a baby in arms. He was no longer breastfeeding, but he still needed the nurturing of his mother. So as just by way of background, just to, let people know my relevance and the angle from which I intend to present this short words. At that time, my mother-in-law was still alive, bless her. And also I had an older cousin, so I was one of those who had the traditional setup, which may not be the usual these days, where my mother-in-law we were living together. I also had an older cousin, so they were in permanent residence. And even then, the hiring of housekeepers or house help was not very difficult at that time. It wasn't as risky as it is now, so we had a lot of house help going in and out. Of course, my late mother was also there, but she was what I call a professional grandma. She was, she was high up on the professional level. And so, her own time was not a 24-hour thing. But I've decided to discuss this aspect of this very topical issue in practical and informal terms, because I'm sure we're not here to be lectured with theories and or case citations. However, it is good to start with the notion that whilst Nigerian law does not contain comprehensive statutory provisions, especially on the topic, several legal frameworks and judicial pronouncements acknowledge the importance of certain principles. So I'll just run through them very, very quickly. Section 36, of course, of the Constitution of the Federal Republic, we're all aware of that, which postulates for fair hearing and access to justice. And so in the sense that the courts must be functional and efficient and structured, because that word is going to come up a lot, in such a way as to allow parties, including those with disabilities, to access justice. Now, the question one asks, especially because people with disabilities, it's politically correct now to just say challenge. So the question is, does that include pregnant judicial officers? Are they challenged, or are they perceived as challenged in the productivity, and then there's the Discrimination, of course, Against Persons with Disabilities Act, which is 2018. And of course, that provides for provision that will ease access into courts. Right now, I'm not aware that there's any judge in our jurisdiction that is challenged in that way. But nonetheless, it is something that there are many lawyers. In fact, recently, I believe there was a senior advocate, though a man, who is physically challenged. And so the issue of ramps, lifts, restrooms, that's what that act does. More relevant to us as judges is judicial welfare and working conditions. Although there is no specific statute or addressing judicial work-life balance, the principles of fair hearing, natural justice, and administrative efficiency, as recognized in the case of Federal Civil Service and LIO, emphasize the need for humane and reasonable conditions. Also, the NJC, the National Judicial Council of Nigeria, has issued guidelines aimed at improving the welfare of judicial officers. So in addition, I believe we're on the next slide now. So in addition to that, we also know that July 25 was declared as International Day of Judicial Wellbeing by the United Nations, and that day coincided with the adoption of the Nauru Declaration of Judicial Wellbeing in 2024. So it is a day which aims to raise awareness about physical, mental, and emotional burdens faced by judges, particularly female judges. Then, of course, you have the practice directions in various courts, which were necessitated by COVID, and it prompted our courts to adopt practice directions permitting virtual and remote proceedings, which may also have helped a lot of female judges, because then, as we saw from the pictures that the previous speaker showed, you could actually you could stay home and do, some of those things and then have your remote hearing. So you didn't have to, travel out. It reduced travel demands, and it improved accessibility for litigants. And we personally in Lagos State did, get that guidance from our Honorable Chief Judge, Honorable Justice Aluba. And, the practice directions really helped. I was sitting in the criminal division at the time, and I remember that, we were able to clear out some of the cases, particularly the plea bargains, where there was no controversy as to the cases. And finally, of course, the National Judicial Council guidelines, which I'd already mentioned, and it encourages the adoption of the modern technologies that I've just talked about. And this helps to reduce backlog. So having laid that foundation, I will move swiftly to the, to the subheadings that were given to me to address. And the first one is the gender role. As the previous speaker has also mentioned, that usually when you talk about gender, it connotes a feminist movement in the minds of many, but it's not necessarily so. For example, and she also said that gender she defined it as something that is almost prescribed by society. And what I have said is that many people, why am I getting an echo? Everyone assumes that every woman wants children, or that even those who want children will have them, and further that those who have children will be maternal. It's not always true, but that's a different topic. Some men are even more maternal and hands-on than their wives or mothers of their children. So having said that, as women, our roles appear to have been genetically, morally, physically, and culturally ingrained in society, and fully oriented to being the main caregiver for the caring and nurturing of the home and children, whether fairly or unfairly. So while most women are trying to forge a career path, there's always that gender role reminder at the back of the mind. How will my husband or partner cope? Will he approve when I want to take up a position? I think you can move to the next slide, or I think I've gone to about the fourth slide now. Will he approve when I want to take up a position, far from home, or have to attend conferences or retreats out of jurisdiction, or even work very late into the night? What will happen to the children? There could be personal guilt even for the judicial officer or the woman leaving everyone. For example, as earlier stated, I am currently on secondment by the NJC to the Gambia, and sitting here as a judge. And the surprising thing is that even at my age, and we are empty nesters, I'm over 60, my husband is nearing 70, yet these questions are still being asked, as relevant, especially to the husband. Oh, why did you know? How can you leave your husband at home, etc., etc. But I'm not an ultra feminist, and I married a traditional man who is almost 70, who was never really hands-on physically too involved in caring for the children. I mean, he didn't change nappies and things like that, even doing too many school runs. So that burden fell fully on me. I knew it, accepted it, and probably because I had a father who was, cutting, from the same cloth. So I learned not to expect it. So having said that, of course, as women, as human beings, you expect some help from time to time. But before I go into the caregiver role, I just want to give two examples of the type of thing that a woman needs to do sometimes. My late father came visiting once, and with so many children, under, say, the age of 10 at the time, I had my two daughters and a son. And the noise level was such that he just couldn't stand it. But I had zoomed out, I was completely at ease with the noise. I was able to try to have a conversation with him, but he was not able to have a conversation with me. It was just like, can't you hear this noise? And, so these are the sort of things that a woman may have to do to cope with work, because if you don't do that, you will find out that, you might get overwhelmed. So this leads to the second subtopic. I think I'm going a bit fast for the slides. So I think you can move. Yes, you can move to the next slide. I think I've covered that. I've covered that as well. And I've covered that. Yes. And then I'm now on the actual subtopic of the gender. So the next slide, please. Oh. Okay, no. All right. So what has happened is that you can go to the previous slide. The topics have not been moved. You can move back. So it leads to the second subtopic, which I was given, which is the caregiver role and its impact on women's career. I'm not sure that the slides are completely covering what we had to say. And this impact, of course, as the previous speakers have said, cannot be measured empirically, because some of the sacrifices of caregiving by women, especially career women, is not easy to quantify. It's of inestimable value. For example, I had to rush home during my lunch break to pick the children up from nurseries. When you go there, you are not sure what you will meet, the house help on top of it. Is the child well? And each day was never the same, So you may have calls to the office, from the office saying there's something to be done. And I'm juxtaposing pre and post judicial experience now. So as earlier said as well, without having to repeat oneself, some women lose jobs on the way because of this lack of flexibility, in trying to balance these two things. And I was discussing with some of my colleagues before this webinar, and we were talking about how women, actually career women, especially judicial officers, you finish your work in court, you go back to chambers, you do the same as your male colleagues, but then you have to start another job when you get back to your home. So you're doing everything that is shown in those pictures again. So it's a burden and a ball, or you're juggling balls that maybe our male counterparts may not need to do. And so this may lead, in some cases, to early retirement. It may lead to, illness, which you have to manage. I know a retired judge who retired recently voluntarily because her hand, she was using her hand because of the manual situation in certain courts. And her doctors advised her that, she might lose use of that hand if she doesn't give up the job. So she had to give up the job. As they said earlier, as the speaker said, some are overlooked for promotion because of the output. Productivity may be low depending on what the support system in your home is. Unfortunately, childbearing is not something that most women can postpone biologically until they have reached the pinnacle of their career where they can control their time. But of course, it's easier in recent times now with the option of sperm banks, adoption, surrogacy, and things like that. And some women, in order to manage this juggling, have had to take children to work. Some judicial officers have had to do that. I know a judge colleague who initially was offered judgeship, but she took on being a magistrate first because she said she had she wanted to care for her children. She wanted to be hands-on. And what then happened was that this was in 2001, and it took her 20 years before she could become a judge, something she didn't envisage. She just thought, I'll take off a few years and try to, care for my young children. And so she was appointed as a magistrate at the same time as we were appointed judges. And she's only just been appointed a judge maybe 4 years or 5 years ago, which was not her expectation at all. Another colleague had to take her children in because she said they only had male house help at the time, and she had 3 girls, little girls at home. So the issue of leaving them at home was not possible. And she was a magistrate for many years, just so that she could ensure that she had this direct oversight on her children. So there are also lawyer friends who gave up work simply because their husbands insisted that they do so to look after the house. And in one case, it was particularly ludicrous because apparently the husband came home and found the children in all sorts of states of half undressed and not looking unkempt, and insisted that she should stay home because he didn't like the way the children looked. And then another has an autistic son. So, she had dreams of coming onto the bench, but she was finding it very, very challenging at the time she had her son. And so she missed that career path. So, the sacrifice of caregiving cannot be overstated, and it is underrated. And finally, the point needs to be made that when one has made it to a high position or pinnacle of one's career, of course, the higher you go, the busier it gets with more responsibilities, late meetings, training workshops. Some things have to give for the other. So I'm sure we're all familiar, as has been said, with this constant juggling, balancing act. And maintaining a healthy balance has never been easy. It's never easy. And many times you have to, do it on a day-to-day basis so that your mental health is not affected. So the conclusion of this segment is therefore that the manner of impact on career of women in the profession may differ from woman to woman, or the support system in the home, number of children, no children, the spouse, the partner, if any, the location of your work, the court. This previous speaker had said how some women didn't want to go to the outskirts, or they feel that certain places are more attuned to a man. Even in the Gambia where I am now, some of us are running away from distances like Basse, which is like going to Badagry, or other distances, Brikama. We want to be in the center. We want to be in Banjul or Bakau or Kanifing, which are closer to the center for obvious reasons, which had been highlighted before. So, whilst it's the sacrifice, you have to make the sacrifice, because of all these factors, it may come with its own collateral damage, which has been highlighted by this previous speaker, of slow career movements, delays, even in coming on board and, so many other things. And even though the previous speaker had said something about it may not be because of all these things, but just because you're a woman. But the fact that you're a woman and have to do these things is also, in my humble view, a factor that could put some hurdles in the way of career progress. And then the third subheading, which I was asked to speak on, is the practical and institutional support. And I speak from the judicial perspective of 24 years post-appointment, especially as we're getting younger and younger judges of childbearing age, as we were at the time of our appointment. There needs to be legislative intervention. I think we can go to the next slide and the next one. Yes, and so there needs to be legislative intervention, a more robust maternity leave inserted in employment contracts by way of, amendments or specific legislation that addresses this gap or lacuna to allow for some leave before the birth of the child, for example, and rest after, or for, illnesses that are female related, not necessarily, not necessarily pregnancy even. In the European Community law, for example, some countries, it allows some men in paid employment to take paid time off as well. So if they take time off and that support is there, then it helps. The Maternity Protection Act 1994 entitles a pregnant employee to, in that jurisdiction, to 18 consecutive weeks of maternity leave around the time of birth. In Nigeria, public service employees are entitled to 12 weeks of maternity leave, often paid at 50% only of their salary. This should not be, but it could vary in different sectors of public and civil service. But I think my colleague coming with the next paper, she has a more practical experience of what she faced with that. However, this entitlement only kicks in if the employee has worked for a minimum of 6 months. So I refer to the Labour Act of TAP L1, Laws of the Federation 2024, and then the 1999 Constitution, of course, as amended. In the Gambia, the General Labour Act 2023 applies along with their public service rules and regulations to time that can be taken off for maternity leave, which is 14 weeks of paid maternity leave, which taken as 6 weeks before and 6 weeks after. I know that amounts to 12 weeks, but I think it's like working days, not including weekends, or you can take the full 14 weeks after. But to qualify for paid leave, an employee must have worked for that same employer for at least 2 years. Otherwise, you can only get unpaid leave, and written notice and a medical certificate are required to confirm your pregnancy, the expected date of delivery. I have a colleague who just had a child a year ago. In fact, she's my next door neighbor in the Gambia here, and her experience was that there was no real provision. They were working with different rules, and so that's why we're asking for a concrete legislative intervention, especially in our common law jurisdictions, so that at least we can borrow from each other. I'm also advocating infrastructure and equipment development. So apart from the retro living courtrooms that are designing new ones to address accessibilities to persons with disabilities, and I say that again as persons with challenges, because even when you're talking about a pregnant judicial officer, not everybody can carry the pregnancy properly. Are there lifts? For example, if a judge has to go to the second or third floor in TBS, and that is her condition because we only have stairs when if she wants to keep going, and I don't know if we're aware of a recent post on one of the social media where in Dundee, there's a judge that is actually losing part of his neural functions, but he's still functioning as a judge with the equipment that he needs to be able to speak. So if some of these things can be put in place, then maybe, a disability or, some illness or even pregnancy will not be that much of a hurdle to productivity and impact in justice delivery. I am also advocating a common room, for starters in maybe each court or not each court. What I mean is that each court location. And the reason why I say a common room rather than a creche is because, as the previous speaker said, there's always a pushback when you're trying to push something for female gender things, only. The world wants to go gender neutral. And so my suggestion is really based on that foundation that there could be a common room which would then accommodate whether you're male or your female colleagues, but then it could have a creche attached to it, or which would then be child-friendly and purpose-built for comfortable cubicles for nursing, for example, and have food, and then people there can be employed, 1 or 2 people can be employed, or even judicial officers can bring their own staff in. But more importantly, it will provide a place where judges can converge, and we can now again be our brother's keeper or sister's keeper, if you prefer. And of course, we're in the digital age, so it will mean that there could be CCTV cameras in there, which we can access because there are apps, for you to access in your home now from your phone. So, if that kind of app can be established, then whilst you're even in between cases, especially now that we're going in for slotting, time slotting. Gambia is a big thing where cases are time slotted. So whilst it's a bit disruptive, because if one case doesn't flow into the other, you have to rise and come back and all that. But if that is the situation, then it gives that judicial officer an opportunity to check what is happening in that common room, or even to stroll down there, to ensure that whatever the child that they brought in is okay. So, it then establishes that saying that, it takes a village to raise a child, and then we can begin to help one another. Of course, orthopedic chairs are very, very important to assist the judges, because it's a sedentary job. You're back. Again, if you're talking about pregnant colleagues and all that. But more importantly, I think we underestimate the power of regular checks by doctors and nurses in the court clinic. I don't think that what we have now, that, if you meet something, just call the clinic. I don't think that is enough. I think the wellness should be that the doctors, are able to go around and check on because many times you're so busy that, you just come in, do your work and go home. Whereas I believe we have clinics in the Lagos State Judiciary, both in Ikeja and Lagos, and it would be good if they could, sometimes just get up and the doctors or the nurses and check periodically on the judges. So they should do checking up rounds instead of just waiting for the judicial officers, particularly the women, to come, because it could just be a matter of a hormonal, problem, or which may lead to swollen legs, or because you're sitting all the time and all this sort of thing. So anyway, so my third is the technological enhancement or integration, which of course, I talked about before, where not only we advocate for flexible hours, but more virtual sittings. In the Gambia right now, they only have like 6 pilot courts, And I'm really pushing for the equipment to transcribe, because I said I came from a jurisdiction where I stopped writing, and it's obvious what you can achieve when there's the equipment for recording and things. But some of the colleagues who have that in their court, not only are they not writing, which is helping their physical health, but the output is, we can't compare to those who are still on the manual train, So, of course, we still have to cross the hurdle of the legality of public hearings as prescribed in our Nigerian constitution. We're all aware of the Supreme Court case of AG Lagos State and AG Federation. Paros Viver J, who JSC, retired, GCFR, who made that statement obiter because there wasn't an actual substantive issue to be discussed, apparently. So infusion of the electronic filing and case management systems to reduce the physical strain and improve the efficiency. Now, the fourth one I put out was the mental and physical wellness programs for judicial officers. That is very, very important because we go for so many other trainings, but recently, especially at the recent Commonwealth Magistrates and Judges Conference, which I attended back in my base in the Gambia, it was a very big thing based on the Nauru Declaration, which I talked about earlier, that it is so important that the wellness and physical programs be infused into the judicial officers, especially the female judicial officers, who, as we have said, are doing two roles at the best of times. If it's not with your partner or your husband, then it's with your husband and children and all that. So it's very, very important that those kind of programs be infused. I know that in Lagos State, we have the Recreation Center, which really is available, for judges to go there and swim and have exercises. But I think a more structured or formalized program needs to be in place so that we know that every Friday there's an aerobics instructor or, a swim coach or something. And, judges can be encouraged to go there. And that is female friendly, because you don't want to go to a place where you're exposing your whole body to the whole world, because in this digital age, once anybody takes a picture, it can be on social media in minutes. Okay, then also the physical and cultural safety at work, which I believe the previous speaker also talked about. If you're going to be sent to the outskirts, what are the security measures that are in place against protecting against threats, violence, harassments, and things like that. Yes, I'm almost concluding, my lady. And then the continuous training, which is very, very important for us as judicial officers, so that we can manage our time properly, stress and reduce stress, and especially with the use of these assistive technologies, AI tools, and the like. And lastly, policy development, encouragement of the overall judicial body, in our case, the NJC, the Chief Justice, Chief Judges, to develop comprehensive policies addressing workloads, leave schedules, mental health support for judicial officers in general, but also now that we have, as been mentioned, two distinguished females at the helm of the appellate courts, that slant be given to the policy development in this regard. So in conclusion, these suggestions, I believe, are practical, they are practicable, and hopefully they can be implemented in the foreseeable future. Thank you very much.
Thank you so much. Thank you very much, Justice Coker. I thank you so much for sharing all of those personal experiences and insights. I particularly enjoyed the manner in which you had to juggle, life and try to create that balance. Well, of course, with that family support that you had. Thank you so much. And of course, some of the other suggestions on how we can further help to implement institutional support and all. Thank you so much. I'm going to quickly move to the second speaker. There's quite a lot of questions here, but I think since it's still the same title of gender concept, I'll just hold on to the questions for Justice Coker and then take the next speaker, and then maybe then we can take the questions together. The questions regarding pregnancy, about your Gambian experience and all of that, but I'll hold on to that because we're running behind time now. I'm going to very quickly call on the second speaker, Ms. Honorable Justice Efunkumbi, another Josephine, of the Lagos State High Court. And then she will, of course, be deepening further this conversation on well-being, caregiver, balancing, and institutional support. Honorable Justice Josephine Efunkumbi of the Lagos State High Court will also share practical experience and personal experience, I beg your pardon, on practical measures and how the court can further implement and support that would help women to thrive and to grow within the judiciary. Honorable Justice Efunkumbi Oyefeso, the floor is yours. Thank you.
Thank you very much, our moderator for today, and thank you very much for everyone that has spoken earlier. I want to please stand on all the already established protocols by our moderator and by Honorable Justice Coker, who spoke earlier. Ladies and gentlemen, I count it a great privilege to have been asked to contribute to this most important discourse at this time, enhancing work-life balance and accessibility in court settings. This webinar is coming at a time when we as judges need to take charge of our total well-being to ensure that no aspect of our lives is allowed to suffer. I will start with the definition of terms. What is work-life balance? Simply put, it is finding a healthy equilibrium between work and personal activities, work and family, or work and your physical, mental, emotional well-being, which are all critical and demand equal amounts of attention. What is the use of having a flourishing and successful career on the bench and your children and home is in disarray because you neglected one in favor of the other? On the converse, what is the use of having a beautiful family and your work suffers because you do not pay adequate attention to it? There must be a balance. We must find a way to ensure that we do not sacrifice any one aspect of our lives in favor of the other. The key is balance. My presentation focuses on maternity leave and career, the caregiver role and its impact on women's careers, and case studies of courts and organizations with dedicated facilities. I start off with a personal story of my own. I was sworn in to the High Court bench on the 24th of May, 2001, at the age of 40. I had 2 children at the time who were aged 5 and 6 respectively. I was done with having children, or so I thought. God had other plans. I wasn't aware. 2 years later, I began to feel funny. My sister, who is an orthodontist, advised me to do a pregnancy test. And I was like, pregnancy? No way, that's not possible. She went out herself and bought the test kit because I was having none of that. I did the test, and lo and behold, it came out positive. I was shocked. I was flabbergasted. Every adjective you can use. It was not on my radar at all. Also, from what I had gathered, it had never happened on the High Court bench in Lagos. So what did I do? I put all my efforts I put my all into my work. I did not allow pregnancy to affect my output. And I know that, it doesn't happen like that for everyone, but I thank God that I was able to. I sat every day. My rulings and my judgments were delivered as and when due. I sat till Friday, the 5th of March. I had my baby on Monday, the 8th of March, 2004. In fact, many lawyers who are attending my court regularly did not even know that I was pregnant, all thanks to the sitting gown that we all wear. I had my baby, and then the back and forth began. There was no policy in place for maternity leave for judges, as the need had never arisen before that time. The question was, what do we do? How do we deal with this? Eventually, the then Honorable Chief Judge of Lagos State, Honorable Justice Shotuminu of blessed memory, decided to follow the Lagos State's public service rules. At that time, it was 3 months maternity leave. There were no facilities or policy in place when I resumed from maternity leave. It was all a learning curve, not only for me, but for the Lagos State Judiciary. I had to juggle sitting, rulings, judgments, caring for a newborn with all that it entails. It was a trying time for me, but God helped me to weather the storm. My husband was also a very hands-on dad, and so he did the school runs for the 2 older children and generally tried to take the stress off me. I was also able to engage a nanny, Mamola, who looked after my mother till she passed in 2003. Today, that baby is 21 years old, to the glory of God. So who is a caregiver and what is their role? A caregiver is someone who provides physical, emotional, psychological, moral, educational, and sometimes even financial support to improve the quality of life. In this context and in this climate, when it comes to providing physical and emotional support, taking care of the household and keeping it, it falls squarely on the mother. Mothers wear multiple hats and must perform also in the workplace. The caregiver role comes with its challenges, which the speakers before me have highlighted, including career stagnation. What impact does a caregiver role have on our career on the bench? A mother is a nurturer. She has to juggle taking care of her husband, the children, taking care of the home, and at the same time, taking care of her work, writing rulings, judgments, court sittings, ensuring that she meets up with the Nigerian Judicial Council deadlines. Most of the time, work does not finish in court. In fact, this work is never ending. You have to take your work home, write your judgments, sometimes staying up late into the night to complete your assignments. It is indeed a challenge, juggling career, growth, and caregiving all at the same time. When babies are at the toddler stage, it is very necessary for us to get the required support from husbands, from mothers, from nannies, grandpas, grandmas. In the times we live in, however, getting someone trustworthy may be an uphill task. But I think that when you become empty nesters, as most of the judges are, it becomes easier to commit fully or better to your work. There is no doubt that there are barriers in the way of women who seek a judicial career in many climes. Their traditional role as women as caregivers, the demanding work schedules, the heavy dockets contribute in no small measure to the biases against women. In many countries, the story is changing. As at March 2025, 31.5% of judges in Nigeria are women, and the number keeps increasing year by year. The increasing number of women on the bench challenges stereotypes and public perception. In spite of their demanding roles at home and at work, women are seen to be fair, to be dedicated, to be very hardworking in the discharge of their judicial functions. Today, the Lagos State Public Service rules have been improved since 2014, somewhat in relation to maternity and career. Since then, Ekiti and Enugu states have also improved on maternity leave. A lot more, however, needs to be done. The Lagos State Public Service rules is followed by the magistracy in Lagos State. According to Section 2, paragraph 120235A, a female officer who is pregnant is entitled to 24 weeks maternity leave with full pay in the case of her first 2 deliveries. The leave commences 2 weeks before her expected date of delivery, and any third and subsequent deliveries attract only 12 weeks maternity leave. Annual leave for that year is regarded as part of maternity leave. And where the annual leave has already been enjoyed, the grant of maternity leave will be without pay. Section 2, paragraph 236 provides that a female officer nursing a child shall be granted 2 hours off duty every day, up to a maximum of 6 months from the date she resumes duty from her maternity leave. The rules go further to provide in Section 2, paragraph 120237 for paternity leave for our husbands, 10 consecutive days in relation to the first 2 deliveries only. He is not entitled to paternity leave for the third and subsequent deliveries. Approval is subject to the presentation of the child's birth certificate or letter of release as applicable. The 24 weeks maternity leave is in line with the World Health Organization, WHO, which prescribes 6 months exclusive breastfeeding. The Lagos State Health Policy also supports this. The private sector is generally benchmarked in line with the Nigerian Labour Act, which mandates only 12 weeks of maternity leave paid at a minimum of 50% of the employee's wage. Many private companies follow this minimum, which is often seen as insufficient in duration and financial support. At the federal level, the Federal Civil Service Rules, revised in 2023, prescribes 112 working days at a stretch, beginning not less than 28 days from the expected date of the delivery with full pay. Annual leave for that year is regarded as part of maternity leave. Where the annual leave has already been enjoyed before the grant of maternity leave, that part of the maternity leave will be without pay. That's chapter 12, paragraph 120218. On resumption after maternity leave, the female staff is granted 2 hours off duty for a maximum of 6 months. Paternity leave is also granted before or after delivery for a period of 14 working days, and not more than once in 2 years for a maximum of 4 children. It is recommended that a unified position should be legislated to align with global standards. The 24-week in Lagos State leave in Lagos State and 112 days leave in the Federal Civil Service should be extended to other pregnancies. It should be a minimum health requirement for both mother and child. Further, we advocate that there should be on-site breastfeeding rooms, flexible work hours, creches to support nursing mothers so that they can focus on their work and also attend to their babies as and when necessary. We know that maternity leave is an employee benefit that is available in almost all countries that provide paid time off to care for a child. But in a handful of countries, maternity leave provides only unpaid time off work. The duration of leave varies from country to country. In the United Kingdom, maternity leave is 52 weeks, while paternity leave is 2 weeks in the first 8 weeks after birth, or up to 26 weeks if the mother returns to work before the end of her leave period. In the United States, maternity leave is 12 weeks, while paternity leave is dependent upon the employer. While in Russia, the leave is 140 days, while paternity leave is non-existent. In South Africa, maternity leave is 4 months, and like in Russia, paternity leave is non-existent. One of the top-tier law firms in Lagos also has a policy of 6 months for senior lawyers and heads of departments, fully paid, and 6 months closing early on resumption. They have a paternity leave policy of 1 month so that the family can bond together. They also have a creche, so mothers can bring in their children and their nannies to work. The creche is manned by full-time staff, and there are CCTVs linked to the parents' phones for close monitoring and to give added peace of mind. This is truly commendable. Maintaining a healthy work-life balance is so vital so as to avoid burnout. Signs of burnout include chronic fatigue, irritability, difficulty concentrating, reduced patience, high levels of stress, and also guilt for not doing enough either at work or with family. I'm sure many of the judges on this call will probably be able to pick out 1 or 2 of these areas. Many judges also experience headaches, back pain, feelings of isolation. So what can we do to avoid burnout? Number 1, we need to share the load. We need to accept support and delegate where necessary and where possible. Grandma, grandpa, your siblings are an invaluable community that you must lean on. At work, judicial assistants who help with research. Well-trained staff can also help lighten the load. We must also embrace IT, learn to use our computers, laptops, iPads, etc. It makes the work easier and lighter. It is never too late to start. In fact, the person that gingered me into learning how to use the computer started at the age of 55. And when I watched this professor gentleman, he typed everything. And I was wondering, how could he learn at such a late stage? So I started. And I started picking. But now it's a different story. You think, oh, this person is a veteran. Number 2, we need to set realistic goals, boundaries, and expectations. We need to avoid procrastination. Number 3, we need to create time to rest. Rest is critical, especially with our job. Take a nap during the day. It helps to fire you up for your work. In fact, someone was saying yesterday that I was discussing with that sometimes a 10-minute nap will seem as though you have slept for 2-3 hours. It is vital. When we do not make time to rest, it has all kinds of health implications. We must rest. Number 4, exercise. We must go on regular walks. Having a treadmill at home may also help. Go swimming, Get out and about. Make sure you keep your body moving. Sitting all day in court, doing what you enjoy doing as a family. Number 6, schedule me time. And I am big on me time. Prioritize self-care. What are the things that you enjoy doing? For me, making a day out of getting my hair done, getting my nails done is therapeutic. I take myself out to lunch sometimes. That is something I also enjoy. Doing crossword puzzles, reading books, I also love. Traveling, listening to music, I also love. For some, it may be a spa day. It may be going to the cinema. It may be traveling, watching movies, listening to music. Do whatever makes you happy. Do what makes you relax. Make yourself a priority. You only have one life to live. Therefore, enjoy your life. I trust that we have been able to take 1 or 2 things away from this presentation. I want to thank everyone for listening. And I say thank you also to the organizers. Thank you.
Thank you so very much, Honorable Justice Josephine Efukubi Oyefeso. Thank you very much for sharing those personal details and experiences. Thank you for all of those insights and advice that you've been able to impart today. Thank you. I have a few questions, and we have to move very quickly because we're running out of time. We ought to have finished this session for now. So I'll take the next 5 to 10 minutes. A few questions. Already I have some here relayed for both speakers, because we need to quickly move to the next plenary session now. I think I particularly enjoyed this me time that is advocated by the second speaker. And we've always been taught how to try to put on your mask first and also wear your life jacket, because after all, you need to save yourself before you save your child. So I have one on timing of judicial career. I think this is for Justice Coker. When you explain the fact that you cannot delay childbearing, and the fact that that has to be balanced with professionalism and also doing your work. So my question is, what are your thoughts on how a woman, for instance, in childbearing age, how she can, regardless of all of those challenges, still dive in and plunge into the appointment of being a judicial officer while still in the childbearing age, because a further delay might jeopardize her growth in the judiciary. So what are your thoughts specific on that? Should I ask the other questions? There are just 2 more questions, or allow you to answer that, Honorable Justice Coker. There's also the question on advice and counsel you can offer to women currently on the judiciary and those aspiring to join the judiciary on balance and how to balance the professional responsibilities with the life and the home front. Of course, there's also the question on some of the insights that you gave on Gambia and how I think there's a comparative analysis basically of the time and duration given in both jurisdictions, Nigeria and Gambia, for maternity leave. I think you did mention that. So yes, and then finally, one more. I didn't know whether the perception is whether pregnancy is sometimes seen as a disability. I didn't get that. I'd like you to share.
All right, because of avoidance of time, I'll start with the last question because yes, I did state as I was presenting that our job as judicial officers rests a lot on perception. Perception is key. Justice must not only be done, but seen to be done. And so pregnancy is not something that, well, first of all, judicial office was almost like a male preserve. So now that a lot of women are coming on board, the last thing you want to be doing is really doing this natural thing of getting pregnant, on the bench, because not every pregnancy in every woman is the same. Justice Orifeso was particularly lucky with the grace of God, but others may have a difficult time of it. So how do people perceive you if you're having 1, 2, 3, 4 children on the bench and you're taking so much time off because you're ill and your productivity is low? So it's that's why I say that it's a challenge. And I swapped it with the disabilities that I said before, that it's a challenge, but it's something that can be supported. If it is supported, maybe lifts to higher floors, like I said, the common room, good chairs, even equipment for remote hearing so that you don't have to move so far, So that's what I said. So it's not a disability in itself, but it can be perceived as a hurdle to high productivity, especially if you're just starting your childbearing, And then you asked me, I think you talked about what I would advise, younger judges or younger women who want to come on board or who have been on board. The truth of the matter is that the younger you are, the more productive you are. So I will not advocate the old system where people were waiting until people were really next to, old before they appointed. Appointing young judges is a very, very good thing because it also gives them a good amount of time to ascend to the highest courts of the land. But at the same time, you have to consider that you still have to do that female gender thing if you want. Of course, it's optional to have children. So you have to think about that this work is a continuum. It's not something where you write one judgment today and you know what I mean, and you're done. It's like swimming and coming up for air. So, you have to keep going. So you have to think properly. Can I do this? Because I know for a fact that many judges come on board and they just cannot understand that is what it is and they cannot cope. So you have to be mentally prepared for that continuum. And it's a thankless job, so you have, the fact that because of the Audi alterum patem, rule of advocacy and, somebody's going to lose and somebody's going to win. And so you will have that backlash. So, you may not always get good positive response for the hard work that you have put in. So those are the kind of things a younger judge or a younger person should look at, in addition to the fact that the support system is not quite there. So you have to do some of this support by yourself, both from home and at work. I think I've covered the 4 questions, or is there anything else that you raised? But I think the paper has pretty much covered it, but I hope these answers have answered all 4. Or was there one more, my lord?
The comparative.
Okay, the comparative. Yes. In the Gambia, it's a Muslim country, essentially. But I'm glad to report that there are quite a few women on board, and there are quite a few young women that have been appointed to the bench, which I was quite impressed about. And they're doing their work very well. But they don't also have, I've not noticed any significant separate support system for us as women. There's no special treatment, there's no support yet. And in fact, it appears that the men are being, if I can say so, more favored with more equipment to assist them, whereas it's us that actually need it more because, you know, we have a lot that we need to do. So I don't think, well, as I've highlighted the maternity situation and all that, but I don't know that we don't have a creche, for example, in the High Court. So, you know, these are things that, you know, if they take up these suggestions, they may be able to do, you know, so. Thank you. I hope that has answered.
That is fine. Thank you so much. Thank you. Very quickly, Justice Oyefas, could you kindly unmute yourself as well? There are quite a number of questions relating to your paper as well. One is, somebody wants you to elaborate on how that lack of formal maternity leave system, how you were able to solve that, I think. Yes.
I think I said it in the paper. After the baby came, there was no policy in place. And it became a question of what do we do? So eventually, the then Chief Judge then used the Lagos State Public Service rules at the time, which prescribed 3 months maternity leave. So that's what I was given.
Okay. Plus also, you're not an advocate, just like Justice Coker, of completing childbearing and child having first before you join the judiciary. You would say going, but have institutional support that would help whoever to continue thriving regardless of having children.
I believe that women, like Justice Coker said earlier, the earlier, the better you come on the bench. But your mindset must be prepared because there are no creches. You have to be ready to do a lot for yourself. I mean, thankfully, we all have our chambers. You can bring your baby in with your nanny if you have one, or else leave your baby with your parents, your husband, your siblings. But we must take care that we ensure that we give them the very best, watching over them, guiding them, guarding them, whosoever is taking care of the children. Like I said, bring your baby into chambers. You go into court, the baby is in here. For me, I have my chambers. I also have a little anteroom. So I can use that, you know, for the baby. And everything works out well at the end of the day. But whosoever is coming on the bench must realize that it's a do-it-yourself system. Right now, we don't have all those institutional support that we need to really go all out. But I think that there is nothing wrong with coming in early. Thank you.
So I think that last comment are taking care of this question that says, based on your observations and experiences, are there specific policies or institutional arrangements such as creches, flexible work hours, or nursing facilities that you believe should be implemented to better support women in the judiciary? So there aren't any, as far as you're concerned, any?
Well, it's not that there aren't any. Your time is yours. You have flexible hours. You can fix time for sitting. And once you fix that time, you ensure that counsel are in court, you finish your cases as and when due, and then you go and do other things. So like Justice Coker was talking about what obtains in the Gambia, you can give them time. I mean, your case is coming up 10 to 10:15, and devote that time to that case. And, you know, once you do that, you are able to be flexible yourself. You can take time out, come back into chambers, take a nap, have a cup of coffee or tea or whatever, go back in, watch over your baby. If your baby is in court with you, you know, spend a little time and then go back into court. So really and truly, it's a do-it-yourself system, but there are, you know, your time is yours and you can, you know, be flexible a bit with your time. Thank you.
Finally, what advice would you give to women aspiring to join the judiciary or those already serving on sustaining their work-life balance while ensuring professional excellence?
I think I went into great detail on that in the paper, and it just flows from that. Scheduling your work, sharing the workload, make time out to exercise, take a nap in the middle of the day. It does help. You know, when you come back to do your work, everything just flows because you have had that little bit of shut eye. You take yourself out. I cannot emphasize this enough. You know, take yourself out. Look after you. You are important. Like you said, put on your face mask before you help somebody else. If you are not, if you're always irritable, snapping at everybody, it affects the quality of your work. It affects everything that you do. So I would advocate, you know, that you take time out for yourself. Look after you and put in your best in your work. Thank you.
Thank you so much. I cannot thank you enough. Thank you very, very much. On behalf of the organizers, I thank you for that, for the time and the experiences shared. I'm going to very quickly now move to the second session and hand over to Justice, Honorable Justice Angela Obi to moderate that session. Would you kindly unmute yourself, Justice Obi?
Yes, I have. Yes, I have.
This is the session on, again, work-life balance, assistance,
work-life balance,
institutional support. Thank you.
Yes. My Lord, the Honorable Chief Justice of Nigeria, my Lord, the Honorable President of the Customary Court of Appeal, my Lord, the Justices of the Supreme Court, my Lord, the Justices of the Court of Appeal, heads of courts here present, my Lords and participants. This session is another experience sharing session. It is aimed at highlighting the pioneering efforts of some jurisdiction in establishing work balance, work aid structures that will enhance work-life balance and workplace satisfaction. For example, introduction of crèche and nursing rooms. We've heard from previous speakers that this is a necessity and that its importance cannot be overemphasized. To present this session is the Honorable Chief Judge of Abia State, the Honorable Justice Lilian Abai. My Lord, the Honorable Chief Judge is here represented by the Administrative Judge, Honorable Justice Chinwe Inyabo. My Lord is speaking on what inspired the pioneering initiative of introducing a crèche in the premises of the Abia State Judiciary. A crèche, we all know, it's a nursery where babies and young ones are kept and cared for during the working hours of their parents to enable their parents to concentrate at work. Unfortunately, today, our speaker, Honorable Justice Inyabo, is unavailable. She's unable to be with us physically, but she has sent a recorded presentation to show us the pioneering efforts of the Abia State Judiciary in introducing a crèche into the building of the judiciary. Can we give us the recorded, can we have the recorded presentation of my Lord Inyabo, please? Admin?
In my Lord, I might crave your indulgence to adopt the established protocol. My name is Honorable Justice Chinwe Inyabo from Abia State Judiciary, and today I stand in for Honorable Justice Lilian Abai, the Chief Judge of Abia State, who, for reasons of the exigencies of our work, is unable to give this talk today. The talk to be given is on work-life balance assistance in courts and stakeholders' engagements. And the creche and nursing room of the creche and nursing rooms for mothers, the impact of dedicated creche and nursing rooms on career and workplace satisfaction, and examples of court designs and layouts that support work-life balance. When the Chief Judge came into office a couple of years ago, she discovered that the creche we had in the premises of the High Court complex was not in use and appeared to have been abandoned. She took up the challenge to put it back to use, and this came to the notice of the wife of the Executive Governor of Abia State, Her Excellency Mrs. Priscilla Chidinma Oti, who now took it upon herself to renovate the creche. In fact, the renovated creche had been in use for some months before Her Excellency recently commissioned it on the 5th of August, 2025, as part of activities commemorating the World Breastfeeding Week. This creche is run by staff employed by the judiciary, and thus it is a place where fellow judiciary staff are in charge, which gives the nursing mothers and mothers of toddlers, who are also mainly court staff, a sense of familiarity and safety. They feel comfortable leaving their young ones in the care of people they know and can trust. As a matter of fact, I have 2 young women who work directly with me and who used to come to work with their babies. Initially, I found this very distracting because it was difficult to get either of them to give their best, as I understood they had to keep their eyes on their babies, whether asleep or awake. This made each of them appear inefficient and almost incompetent. As soon as the creche came into use, they both took their babies there, and the change in their attitude to work was dramatic. One of them, whose job is mainly to take care of the chambers, would now quickly finish all the chores there and join us in court, where she would sit with the clerk of court and the registrar of the courts. She has now graduated, actually, to calling out the names of parties in courts as part of proceedings. She can sort out case files for the next day and even helps with the interpretation of testimonies of witnesses in English and Igbo languages. Just today, the clerk of courts, who is unable to be in court today with us because of ill health, it made the job a bit difficult for the court registry alone. It was this young woman who, having been able to learn so quickly as soon as she was free of having her baby with her always, she was in court to stand in the stead of the absent staff. Subsequently, this young lady has registered for a part-time course to upgrade her qualifications, all because she found she could be more productive once she had that peace of mind of knowing her child was in good hands while she was at work. And the other young mother who types the course lists, the records of proceedings, court orders, quarterly returns, etc., initially used to fall behind with deadlines, as she used to divide her time between attending to her young baby and getting official work done. It was such a relief to all of us when she took us on to the creche. And now suddenly find that she types processes even in advance. And I now have to struggle to keep up with her speed in proofreading the processes typed by her. With just these 2 people, I, as the immediate superior officer, can appreciate the usefulness of the creche, which such young working and nursing mothers can now use. With just these 2 people, I, as the immediate superior officer, can well appreciate the usefulness of the creche, which young nursing mothers and working mothers can now use. For the purpose of this talk, I had to interview these 2 young mothers who work with me, and ask if there are any benefits from having this creche within the High Court premises. The following has been called from the responses they gave to me. The location of the creche within the court premises saves them a lot of time, as they can come straight to work with their children rather than go first to drop off the child at a daycare center before coming to work. Now, all they have to do is walk a very short distance from their office to the creche to drop off the child right within the court premises. Then when work is over, they simply walk over to take their child home with them, saving them the trouble of leaving work early enough to go somewhere else to pick the child before going home. I was also told that it allows such a young working mother to concentrate better on her work without the distraction of managing a child at the workplace. Another benefit is that the proximity of the creche allows mothers to monitor their children more easily, as they can check on them from time to time, especially for the nursing mothers. Nursing mothers also enjoy the privacy of nursing their babies in peace. The proximity of the creche also means that if there is any emergency, the mother can be reached within minutes. The importance of having a creche in the workplace of a nursing mother or mother of a preschool child cannot be overemphasized, as it has proven to be of great benefit to the court staff and users. This is not just for female staff. The husbands of women who have very young children can also benefit from this creche. I understand it's also open to members of the public at a very minimal fee, though we haven't had any yet. And you can imagine magistrates who are still of childbearing age being able to work better if they can have their children there. Or even a judge who decides to adopt a child at an advanced age, she can well concentrate on her work if a child is able to be kept safely at the creche while she's at work. Even the court staff who are in charge of the creche have a ready place to bring their own young ones and can recommend it to other users. Young working mothers who can use the creche are more productive at work, thus enhancing their chances of being promoted because of a better career growth. For me, for this young person in particular who has left her designated role to be able to help out in courts, I would easily, very readily recommend her for promotion because she's quite capable, she's quite competent, and she has done very well since her baby has been able to be at the creche while she's at work. She's done quite well, so has the second person too. So this really helps with their career growth, which can lead to promotions. And to work in any institution where a nursing or working mother with a child is recognized and accommodated in the scheme of work, that must give such a mother a sense of belonging and satisfaction at a place of work. Because let's think about it, having children is a natural way of life. And so pregnancy, becoming a nursing mother, or having a preschool toddler should not be allowed to impede in any way the career growth of any working woman. Any place of work that embraces this by providing creches to give such mothers the peace of mind they require to know that their child is in a safe place and in capable hands ought to be commended, because it shows that the management of such an institution must have a sense of humanity that is not very common in the corporate world. I am therefore very happy, and I must say quite proud of my own Chief Judge, Honorable Justice Lilian Abai, as well as Her Excellency Mrs. Priscilla Chidinma Oti, the wife of the Governor of Abia State, for putting Abia State Judiciary on the list of workplaces with humane consideration for the work-life balance of their female staff who are nursing mothers and mothers to young preschool children. I want to thank you all for your attention. As I leave you now with a video of our push to support work-life balance of our female staff. May God bless you.
Justice Obi, is the video, is it over? Justice Obi. Yes. Justice Obi. Okay. Thank you very much, Honorable Justice Onyango, for sharing that video. Can you mute yourself? Can you mute yourself, Ms. Johanna? Okay. Yes, thank you very much, Abia State, for sharing the video of your creche and also sharing the practical experience of how this institutional support has been able to support productivity and enhance well-being of people in Abia State Judiciary. We're moving very quickly to the third session on policy and design integration. And this session will be moderated by Justice Tamuno Igoni Oji. One of the
Igoni. The full name is Tamuno Igoni. Thank you.
As I separated, I think I thought there were two names.
Tamuno, no, it's just one name. It's Tamuno Igoni is joined together.
Oh, yes, the floor is yours.
Thank you. Thank you so much. Thank you. We've been having an interesting session so far. And may I most humbly stand on the well-established protocol by our main moderator, my Lord Justice Oshodi. Good afternoon, everyone. It's already afternoon. We're going to the third session, which is policy and design integration. And I have a wonderful lady who is going to be handling it. Your Worship, Nkechi Useni, I hope I'm right in pronouncing your name, who is a graduate of the University of Lagos. She graduated in 2001. She's been on the magisterial bench since 2014. And she's very experienced in every aspect of, you know, legal practice and judging, as it were. She's done civil, criminal matters, family matters, election matters. She is very knowledgeable. And the interesting thing is the name is Nkechi. So this topic is really suitable for you because I'm wondering what Nkechi is doing in Cross River State. And now, so it was good you were picked to handle it. And Nkechi is now presently the Chief Registrar of the Customary Court of Appeal in Cross River State. So you're apt, very apt for this topic because it's going to be dealing with concerns on these indigenous issues, indigenization issues, having a policy in place that can safeguard women. Because like Comfort read out about the World Bank data collection, that who decides for the woman where she belongs when she is married? She from her place or her husband's place? These issues are subtle there in the judiciary. Let's see how our speaker will handle it. The floor is yours, Your Worship. You're muted.
You need to unmute yourself.
Good morning, my Lord Oji. Thank you so much for your very generous introduction. May I also toe your line and rest on the existing protocol already so well established by Justice Oshodi. Like you said, my name is Nkechi Usani, and the eyebrows you really are something that I have become used to since moving to Cross River as the Chief Registrar of the Customary Court of Appeal. And we will be talking about the need for a gender policy in the Nigerian judiciary. In this presentation, we will be examining the question of indigenship, the overt and subtle discriminations women face as a result, its impact on career progression in the judiciary. We will see what happens when the cultural assumption that marriage results in a change of where a woman comes from. When this meets formal indigenship requirements, what we will find is that women are systematically displaced from their birth states and their marital states, eligible for appointment nowhere, so to speak. Add to this discrimination against single women, we will see that women's marital status, whatever it is, becomes a professional barrier, whilst happen. As they say, charity begins at home, and so I'll use myself as an example. I was born to an Igbo man from Imo State and an Efik mother. I got married to a proud Yako man from Cross River State. The question then becomes, for my career progression, where exactly do I come from? Am I still from Imo State, which is my birth state? Or by virtue of my being married to my husband, now from Cross River State? Whilst we know that it is legally impossible to change my state of birth, it is also culturally abhorrent, to continue to adopt your birth states after you've been married. Recently, there was a tsunami in the judiciary of Imo State, and a friend of mine who's in the magistracy, and I were talking about it. And she jokingly said, Nkechi, you forgot try your luck for Imo. But we both laughed very hard about it because we both knew what would happen. I would be told summarily to go back to where I was married from. That's what I would have heard. I'd be told, look, we don't know you here, I remember when we first moved to Cross River shortly after we got married, we had a Sunday tradition of visiting my husband's uncle, who was almost like his father, and on one such occasion, someone came to visit that uncle, and I call him my father-in-law, my second father-in-law, was introducing me very proudly to this visitor, and he told him my name, and the guy looked at me quizzically, and then at my father-in-law, and said, Adose, which means in Yaka, she's a stranger. And my father-in-law held me close and said, Adobo, she's just Igbo. But that is the fate of
a married woman in Nigeria. It reminds me of a story I heard about a bat. Most of us think that bats are birds, but they are actually mammals. But what used to happen to the bat is whenever it went for a meeting of mammals, they would say, no, you've got wings, you're a bird. And when it went for the meeting of the birds, they say, no, you're a mammal. That is the quandary married women are faced with. We are called them in March 2020, what certainly I, thought would be a perfunctory screening and confirmation exercise quickly turned into something else. In keeping with constitutional requirements for the swearing in of the Chief Judge, Honorable Justice Akombi Peme, who had been nominated by the National Judicial Council, was presented to the Cross River State House of Assembly. To cut a long story short, her nomination was refused. And the reason that was cited was that she was, in quotes, a security risk. And that was because she was from Akwa Ibom State. It did not matter that Akwa Ibom was carved out of the old Cross River. It did not matter that my lord came from a prestigious family in Cross River and in Akwa Ibom, and in fact was born to a Cross Riverian mother. It did not matter that she had been married to an illustrious Cross River son for many decades. It did not matter that she had enjoyed a sterling career at the Cross River State Ministry of Justice, where she rose to Director of Public Prosecutions before crossing over to the bench, and had enjoyed a couple of decades, 2 decades at least, of a sterling career on the bench. None of that mattered when it was time for her to be made Chief Judge. It took the National NJC standing on the side of the rule of law on that 1 year after. It took 1 year and the NJC for her to be sworn in as substantive Chief Judge of Cross River State. Now, this incident might seem like a one-off, but the seeds were sown many years prior. And I got to know about this when I was talking to a staff of mine who works in the Customary Court of Appeal with me. We are also parishioners in church. And I realized she had a different surname in church than at work. And I said to her one day, and one day I put the name she bears in church. I was addressing something to her, and I put something official to her. And I put the name, her name in church on it. And she was like, Your Worship, no. And I said, why? And it was then that I heard that at the advent of the Fourth Republic, there was a policy in Cross River State that anybody who was not from Cross River State who worked in the civil service had to resign or be sacked. It turned out that that categorization of non-Cross Riverians also included Cross River women who were married to non-Cross Riverians, like this staff. She was married to someone from Benue State. And so to retain her job, she had to, with her family members, go and beg her husband to allow her to revert to her maiden name. And that was the only reason why she retained her job. When I first came to the judiciary, my secretary at the time, Mrs. Anna, whom I fondly called American Gangster, came to me and asked me how I'd like to sign off my letters. And I said, Nkechi, why Usani? And she looked at me and shook her head. And I said, what? And she said, Your Worship, you won't understand. And she went away. The first letter she typed for me, she brought it and it was signed off as Yvonne N. Usani. And I said, Mrs. Anna, this is not what we agreed on. And she said, Your Worship, she went and came back with very dramatically, came back with different iterations. And I said, but this isn't what I asked you to do. And she also told me about this policy. And I said, you know what? Don't worry about it. Just sign off my letters how I asked you to. Now, this specific policy may have been rescinded, quietly. But that principle, the principle that it made explicit, it still operates informally across many states and judiciaries, across many states and institutions, including, sadly, the judiciary. What is the position of the law on this matter? We'll start with the ground norm. The 1999 Constitution, the law from which all other laws derives its potency. Section 14 requires inclusiveness in governance. When a cultural assumption about a woman's identity systematically includes positions of authority, are we being inclusive? Section 17 guarantees equal opportunity. When marriage, something that is a fundamental right, becomes a barrier to professional advancement for one gender but not the other, is that equal opportunity? Section 42 of our Constitution also prohibits discrimination based on circumstances of birth and other grounds. Does whom you marry fall under protected grounds? When marriage displaces a woman from both her birth state and her marital state for purposes of appointment, is that compliant? My lords, these questions aren't rhetorical. As judicial officers, we are required to reconcile these principles with existing practice, and I hope that the conversations that we have here today will form the basis for what we will do going forward. The African Charter on Human Rights as well, which Nigeria has domesticated in its Article 13, guarantees equal access to the public service of this country. The Convention for the Elimination of All Discrimination Against Women, CEDAW, encourages states to take all, emphasis mine, appropriate measures to eliminate all forms of discrimination against women. It's very funny. I was talking to someone in Cross River who is really big on women and children's rights, and he was telling me about the story of trying to domesticate this convention, and how, because of the pushback that was gotten, the different parts of it had to be split up, you know, and it's now found in various legislation like the Child's Rights Act and the VAP Act. So it just brings me to what Justice Oshodi was talking about earlier about pushback. You know, when people talk about things that concern women, there is usually that pushback, and women have to come up with ingenious ways, you know, to work around it. And I believe that that's what we will do here today. Recently, I've had cause to find out what exactly the judicial policy is on recruitment. And there are 4 broad categories which the NJC considers when judges are being appointed. It's skills, competence, integrity, and comportment. And rightly so. These are objective criteria for the appointment of judges. It makes no mention of indigenship, but we know for a fact that this is a major consideration for recruitment. On Tuesday, I was at the Federal Judicial Service Commission attending an interview for appointments to the Federal High Court bench, and I met a lady from one of the northern states, and she told me she is married to a man from that same state. She told me that 10 years ago in 2015, she had done a test for appointment to as a judge in the state, and in the results that were published, she was the highest. However, a petition was written to say that even though she was from the same state, her husband from a different local government, that the petition was based on her being that she was going to take the slot for someone from a local government that she's not from. And on that basis, she was dropped. And she said since then, she has not been shortlisted for appointment in her state until this exercise to the Federal High Court. She said that to preempt any petitions, she had written to my Lord, the Honorable Chief Justice of Nigeria, informing her of these past petitions that had been written and telling her that, in fact, she had dropped her husband's state. The same thing that my staff had to do, she did as well. They had to go to her husband to beg him before she now rescinded her local government of origin, as it were. And we know that these stories are not strange. They happen. When we apply this sort of arbitrary rules to recruitment, what then is the result of these discriminations? I call them, they are, as far as I'm concerned, absurdities and distortions. I will examine some of them. The first absurdity is that we're telling women that their marriage choice, not competence, not integrity, not comportment, not skills, will determine their career ceiling. We're telling them we're creating a system where remaining unmarried is questioned as not being serious enough, but marrying the wrong person can displace you entirely. Either way, women can't win. The third absurdity is that we're saying marry only within your state if you want a judicial career, or you won't be taken seriously. Do we really want to be in the business of dictating both whether and whom women marry? Absurdity 4. A woman can serve a state brilliantly for years, but still be told she doesn't belong there. Meanwhile, a male indigene with fewer years of service, who might be less competent, is automatically more eligible. What is the end result of all of this? If you are married, you're not mature or serious enough. If you marry within your state, well, maybe it might be acceptable. You marry outside your state, you're displaced from both states, whilst for all situations, your male colleague's marital status is irrelevant. These absurdities show up in the numbers. Recently, the Chief Justice of Nigeria, Honorable Justice K.M. Okekere-Ekun, reeled out these statistics that are displayed at a NOJIN conference. And I'll just quickly run through them. In the Supreme Court of Nigeria, the Apex Court, 70% of the judicial officers therein are male. At the Court of Appeal, it is 68%. At the Federal High Court, it is 64%. At the National Industrial Court, 66% are male. At the High Court of Justice, FCT, which has the best stats in favor of women, it is 54% for men. At the state high courts across the country, male judicial officers constitute 64% of those. At the customary courts of appeal across the country, it is 67%. In my courts, it is actually 80%. Of the 5 judges, there is only 1 female on the bench there. Of the heads of both federal and state courts, men constitute 63%, and the total of federal and state courts, men constitute a whopping 68% of the judicial officers. Given the similar legal education enrollment, and in fact, better passage rates for women, enrollment and passage rates for women, this gap suggests systematic barriers, and this comprehensive scrutiny of women's marital status, whatever it is a significant part of that barrier. When a policy or a practice produces absurd outcomes, it is usually a clear signal that reform is required. What we might ask is the vision for the Nigerian judiciary. We've seen what the Constitution talks about. We've also talked about the National Judicial Policy on recruitment. One of the goals of the NJC is that it wants an entrenched and independent judiciary for Nigeria that is committed to the rule of law. Its vision is for a judiciary that is integrity-driven with adequate measures to enhance timely and equitable dispensation of justice in Nigeria. This cannot be achieved when hurdles which have the effect of stunting career growth are placed in women's paths. So what's the solution? How do we honor the legitimate desire for state connection by birth and by marriage without displacing women? I have no answers, but I have a few pointers I will share here that might guide our dialogue and form the basis of a call to action. The first is to create a judicial policy that aims for parity. And what that means is that it is important for us to decide what parity means for us. And this has to be taken into consideration what the society that we live in. The last census, which was conducted in 2006, which was a week after my daughter was born, I remember my mother saying to her, "Oh, you came just in time to be counted." And when the census officials came to our house, they were like, "I have a baby that needs to be counted," you know. That census puts the number of women at exactly half as men in Nigeria. If we look at the numbers for admission into the university to study law, admission to study at the law school, and bar passage rates, we will find that the numbers are similar or higher for women. This needs to reflect in our judicial appointments. It is important for us to recognize multiple forms of connection. I feel just as Igbo as I am Cross Riverian. My mother is Cross River. I speak Efik more fluent than after Yoruba. I am most fluent in Efik. I am married to a proud Cross River man, and my children bear Cross River names. I feel an affinity to Cross River. Our recruitment policy must recognize these multiple forms of connection. We must reject marriage as a disqualifier. Nowadays, women are electing not, women and indeed men are electing not to get married. We talked about women electing not to have children. These are current realities. It must be based on objective parameters. There must be transparency in our recruitment. We must also monitor and evaluate and see if these parameters that we are instituting are achieving the Constitution of Nigeria. Otherwise, we do understand what it means. Let me close with the words of Amy Lewis, who is the Senior Program Officer for this WILIL program. And she says, and I quote, "Achieving gender parity in judicial leadership is not just about fairness. It's about transformation. It strengthens public trust and creates a judiciary that is more inclusive, responsive, and representative of the society it serves. When women lead, communities thrive." My lords, it has been my absolute privilege to present this paper, and I thank you all so very much for the opportunity.
Thank you, Nkechi. There's nothing more to add. You did very well. And I'm sure that one way or the other, you have helped us with a policy statement. And I'm sure we'll take something from your talk for whatever policies WILIL will decide to send to NJC. Thank you, thank you, thank you so much. Over to you, my Lord Oshodi.
Yes, thank you so much. I think that was very, very well done. We enjoyed that session. It was very personal and also very practical and very exciting. Thank you. Can I quickly call now on, we're moving very quickly to the interactive session, which will be anchored by Justice Binta Mohammed of the Abuja High Court. It promises to be very engaging. It allows for participants to share some of their comments and also insights, also experiences and perhaps questions. So I think with the raise of hand, we would allow some comments, few questions or few comments from participants. Justice Mohammed, can you kindly unmute yourself and on video and also allow your Justice Binta Mohammed.
They are trying to set up because I'm on stage. I'm not sitting.
Can we have participants then raising their hands and being unmuted so that they can share their comments?
So good evening. Good morning, my lord. Sorry.
Very well.
My name is Honorable Justice Binta Mohammed of FCT High Court, one of the technical committee members of WILIL. I want to stand on the existing protocols earlier adopted by my sisters in the morning. So my own schedule is just the question and answer sessions. Am I audible? Justice Oshodi. Am I on? Justice Oshodi.
Yes, my lord, we can hear you.
Hello. Okay. So the question and answer session is now on. Anybody with a question can indicate by a show of his or her hands so that we take the questions and accordingly. Or if there's none coming, let me start by asking Honorable Justice Justice Coker, and I want to commend her for her excellent paper and contribution earlier on, and clarify also as regards the 140 days Russia that has indicated maternity leave, and if that is possible in our country. I don't know, some people, some jurisdiction says that maybe around some states that have adopted the 6 months period for maternity leave. I don't know if all states have indicated that in their civil service rules. So I'm not aware of that. And I don't know if that is also obtainable in Lagos State. I think earlier, my Lord Justice Coker stated that 140 days has been adopted in Russia as maternity leave period. So the question is addressed to Honorable Justice Coker, if she can shed light on that. Is Lagos State into that 140 days maternity leave period? Before other participants will indicate any question, I think I want to bring up that issue so that we get more insight as regards the issue.
Thank you, my Lord. But I want to say that that particular segment was actually handled by Justice Oyefeso, because she actually had to trigger the rules because she actually had a baby while she was on the bench. But I am not aware that there's been merging of the provisions. I think she had to resort. I don't know if she's on board still, but she had to resort to the civil service rules for maternity. So, you know, it has not been adopted in any formal form, but she had to resort to the civil service rules, which really is applicable to magistrates and not judges in Lagos State. But if she's still on, I don't know if she can. I don't think she's on. I can't see her on. Maybe she can shed more light on it. Thank you, madam.
Okay, any questions from participants? Any questions, any contributions, recommendations? If it can be online, no problem. We have a recorded version of the program, so at least we will see the questions and also answers as indicated by participants.
Let me also say thank you, my Lord, for the comment on my paper. Thank you. I forgot to start with that. Thank you, my Lord.
So, my Lord, were you the one that, I don't know if it's Justice Coker that stated about the issue of common room instead of crèche? Is it to replace the crèche system, the common room, and which is cheaper amongst the two? I know, of course, the common room will be cheaper than crèche.
Yes. Yes, my Lord, I was the one who suggested the common room. And the suggestion was based on the foundation of the fact that we're going into an age where gender neutrality is seen as a more positive way to get results. Because if you start saying, oh, we want something for women, the men will push back or it will not be passed. So I was suggesting that is a way of including them and still ensuring that we get the crèche attached to such a common room or get what we need in the crèche in the common room so everybody can have access to it. As to whether it will be cheaper or not, it depends on...
Yes, about funding. That is what I mean,
exactly.
being cheaper, about funding.
Yeah, I understand. my lord. Yes, we don't know which one will, it depends what kind of equipment are we putting in the place, what kind of things are going to be there, what is the budget of each state. So it depends on the jurisdiction, in my humble view, as to which one may be easier to do. But may I also say that in Lagos State, because we have family courts, we already have creche-like rooms in some of our courts where some of these children are kept, almost like witness rooms, where some of these children are kept, they're playing so that they are relaxed before they have to give evidence, or before they, that sort of thing. So that idea is already there, but it can be improved upon into like a common room stroke creche.
So, and additionally, my lord, I think with respect to the issues as it relates to interventions, that is court interventions, the presenter, I think either you or Justice Oyefeso mentioned about virtual remote proceedings, travel time, that is in respect of transfers of judges, and practice directions. You see, all these three relates to where our heads of court can intervene. So how do we now, make a lobby group to now try to see that all these things are in place? But I know virtual remote proceedings are on. I know we do it. Then travel time in respect of female judges should be curtailed, probably, and then the practice direction, spelling out all these issues. And this will avoid making a law. The practice directions are easier to come up with. The judges can come up with practice directions in more timely manner than saying, okay, we have to wait, and for interventions, we change the laws to favor women. I don't know.
I totally agree with you, my
yes.
lord. I totally agree that
instead of saying we must change the laws, and then that takes time, a lot of time.
Yes, my lord, yes.
So why don't the heads of courts try to see that all these things are incorporated into our practice directions?
Yes. Your lordship,
and that makes it easier, the rules.
Yes, I agree
All right.
totally. I agree totally, my lord. I agree totally. Yes. And I'm sure we have heads of court on board. So I think ours in Lagos State has been doing that. And as I said in my paper, it was in my paper that it started with the advent of COVID, when we all couldn't even move around at all. So, we were constrained to find a way of continuing with justice delivery. And that was how we came up with practice directions for remote hearing. And I think that was when the Attorney General of Lagos State at the time now decided to take that issue up to the Supreme Court, along with some of his brothers from other states. And even though the issue was not dealt with substantively, at least we had an obiter from the retired Honorable Justice Rose Bible, JSC, GCFR, who then made that comment that, as far as he's concerned, it's a public enough hearing if anybody can come on board. And it complies with the Constitution, the constitutional requirement for a court to sit in public. Thank you.
Okay. Thank you. So any comments from the participants? Let's take comments. Anybody online? Or like I said, we'll just post our recommendations. Pardon me, Justice Oshodi, yes?
I was just going to add to your conversation with them, Justice Coker. I said, I suppose this ability to have these virtual hearings will, of course, assist in terms of flexibility of these women who are also caregivers. So it doesn't really negatively impact on your work. Would you have something also if you cannot be on a particular seat at a particular time. So you can always, for instance, join by Zoom and give your rulings where you're not able to be on your seats. I want to confirm that that's what you're trying, that's the importance, and that's what you're trying to bring out from the use of virtual hearing, my Lord Justice Mohammed.
Yes, virtual hearing had been on since, I think, COVID in 2020. Every jurisdiction, I think, practiced that, but I don't think that is enshrined or ingrained into our laws properly. So
No, I'm just
if practice directions are
narrow it
done,
down. I'm sorry, my Lord. I'm just asking how it directly impacts on this, in aiding structural and institutional support. Where exactly? Yes, I wanted us to narrow it down
of course, a woman that put to bed maybe within a month can do her proceedings in her study at home virtually. I don't know if that is possible, if that would be welcomed, but I think that is also a way out.
It's a proposal, except especially if you can marshal it properly, and I guess if you can properly organize it, I'm sure.
That's why I said it shouldn't be, we shouldn't go to the National Assembly to change the laws. Let the heads of court provide a practice direction and instructions that a so time is so a person can do this, and that is at least is noted at the end of the day.
Very well.
Okay, thank you.
Thank you very much.
So comments, please.
Somebody's saying, I don't think practice direction will solve the problem.
Yes, practice direction will solve the problem since, it's off. Oh, okay, I can see.
I think that some states are beginning to include virtual hearing in their rules of court. In my state, virtual hearing is in our rules of court now. We amended our rules in 2023, I think, and it's part of the rules now.
Yes. It's also in the practice direction, I think number 2, Lagos State as well. Yes, so it's part of the practice direction.
Yes, it has also been introduced in our rules of 2023. It has been embedded there too. So it's not just the practice directive that was issued in 2020. We have it in our rules now as
Very well.
Substantive rule of court.
Very well. Okay. This is Mohammed. Do you want to round up in the absence of any other comments?
Most of the comments are appreciation extended to our speakers.
Yes,
and that's why not comments are coming in, but most of the comments are to appreciate our speakers for this morning.
I see that.
And they are requesting that we officially send to their emails all the papers that had been presented.
Yes, it will be done. I think Justice Balogo in the background is saying she has a question. I'm not sure. Can we?
Yes, thank you.
Okay.
Thank you, Justice Oshodi. Thank you.
Good afternoon, my lord.
Good afternoon. How are you all? And
Very
thank
well,
you for the good work. Thank you, WILIL.
Thank you so much, my lord.
I want to comment that
the feedback form is online as well. The feedback form is online, my lord.
Thank you.
Yes. Maybe we should have all the suggestions, recommendations, and send them to maybe the NJC so that if there can be like a policy on the issue. I believe that once there is a policy, all the states will want to comply. But I think that there have been so many excellent suggestions today, and I say kudos to all of you in WILIL. All the best.
Thank you very much. Well, just before you go, we're working on some proposal on gender policy documents, but we're still, at the teething stage. So eventually have to share it for inputs and comments from all the stakeholders before we eventually present it. We were going to present it at this, but we were thinking we needed to have some inputs from this conversation and also try and tidy it up and dot the I's before presenting it. Thank you so much for that insight. Justice Mohammed, do you still have any comments before we go to the final session? Justice Mohammed.
Pardon?
Justice Mohammed. Any other comments before we leave this session?
No, I think there's one comment from Vivian. Vivian is saying that I don't think practice direction will solve the problem, since the directions supplement the main rules of court. Are there existing rules for this?
Well,
so that's a comment from Vivian, who had also raised her hand.
Okay, that's noted. We'll get back.
And Fatima is saying, I don't think virtual hearing will be practicable in lower courts who deal with litigants at the grassroots.
But why not? We'll get there eventually. That's where we're going.
Yes, exactly. It's a matter of time.
Very well.
Yeah.
Very well. So we were supposed to have ended this session at 1
Like
o'clock.
I have said, it's all appreciation. Most of the comments, 95%, 98% of the comments are just appreciation of the speakers, appreciating the speakers for this morning. So most of the comments are like, yes.
So
yes.
I think it's like we've come to the end, so we should be rounding up now.
We should round up.
Yes.
And then also,
so can the materials be sent to our emails, please? That's the question. Can they be sent
just
to
the
emails?
If every participant can just kindly share their email,
all right.
ensure that the paper
exactly
be sent to them. Yes. Okay.
Yes. They will.
Okay.
Thank you so much, and thank you for your thoughtful engagement and valuable inputs. Thank you. Those insights gathered here today will go a very long way in redefining the proposed gender policy documents that we're working on and in advancing the goals of the WILIL Project, the Women in Leadership and Women in Leadership in Law program. So distinguished colleagues, participants, honorable justices of the judges of the High Court, have now reached this final part of today's webinar. And over the past few years, we have listened, we have reflected, and shared deeply on gender roles and caregiver roles, ensuring that delicate balance between work, life, service, serving the law, and also ensuring that you're preserving yourself. And also on some of the institutional supports and the and policy measures that are. Can you unmute yourself? Can you mute yourself, Justice Mohammed? Please, thank you. Yes, some of the institutional supports and structures that are being put in place to assist and to ensure that women are given the opportunity and platform and also level playing ground, if you say, to excel and to progress in this journey to leadership. We've heard stories, personal stories of courage, of innovation, of how women have also had to marshal and navigate the demands of life and also excel professionally. So just before we totally round up, I just want to call, I don't know if Amy Lewis is here. She's the representative of International Association of Women Judges. Amy, if you want to put in a few comments before we round up.
Yes, of course. Welcome. Good afternoon, everyone.
Good afternoon.
It's been a pleasure to be a part of today's important conversation on enhancing work-life balance and accessibility in court settings. This webinar was more than an event. It was a critical platform to address the systemic challenges women in the legal profession continue to face. And by focusing on family-friendly court facilities, accessible work environments, and inclusive policies, we've highlighted how supporting women's careers strengthens the judiciary as a whole. When courts accommodate the realities of caregiving and accessibility, talent can thrive, career satisfaction is enhanced, and inclusivity becomes the lived reality. We also emphasize the importance of equal opportunity for all, ensuring that no one faces discrimination based on gender and indigenship. Policies that safeguard women from both overt and subtle forms of discrimination help create a judiciary that is fair, representative, and accessible to all. It's also important to note that these are not just women's issues, but affect families and societies as a whole. That's why we need allies, particularly male allies, in this work, as creating supportive and equitable workplace benefits everyone and strengthens the administration of justice overall. The experiences and strategies shared today, from creches and nursing rooms to flexible work policies, provided practical pathways for enhancing career advancement and workplace satisfaction. These discussions will guide policy improvements that benefit not only women judges and lawyers, but all who engage with the justice system. Equally important is the presence of women on the bench and the realization of gender parity in judicial leadership. Women judges bring unique perspectives, experiences, and approaches that enhance the fairness and inclusiveness of justice. Gender-balanced courts better reflect the communities they serve, strengthen public confidence, and help ensure that the judiciary makes decisions that are equitable and responsive to all. IWJ is particularly grateful to Nowgen for leading this webinar, and we're excited about how the WILIL initiative can make important policy inroads to elevate women in the judiciary and create enabling environments for them to thrive. We recognize that meaningful change takes time, but we remain committed to supporting these efforts and ensuring they lead to lasting impact. In short, work-life balance, accessibility, and equal opportunity are not optional. They are essential to a judiciary that truly reflects and represents the communities it serves. I commend the organizers and all their participants for contributing to this dialogue, and I look forward to the continued impact of the strategies and policies discussed here today. Thank you so much.
Thank you, Amy. Thank you so much. Thank you for the comments. So thank you all for your participation, your honesty, and your commitment to advancing women's leadership in the judiciary and the law. My prayer and all our prayers as a committee is that today's conversation continues to inspire the change that we all seek. Thank you so much. Have a good rest of the day. Thank you. That's it. That's the end. Thank you.
Thank you. Thank you, Justice Oshodi.
Well done, Madam Moderator, my Lord Justice Oshodi. Can we leave now? All right. I wish
Very much,
everyone
Justice Coker. Well done.
good evening.
Enjoy
Thank
the
you.
rest of your day
Well
in
done,
Gambia.
moderator, Justice Oshodi, and all of you moderators and everybody. Well done. Well
All the
done.
moderators, yes. Well done.
Thank you very much,
It's an
Justice.
excellent webinar. Enjoyed it.
Thank you.
All right. Bye-bye.
Kindly fill the feedback form space before you leave. Thank you. And don't forget to drop your email addresses so that we can email the papers.